Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Edward Elgar Publishing Limited, who are independent publishers. They produce some really first-class, top-of-the-range books, and this one's on contract law, which is a very important area of law. It's the cornerstone, of course, of the common law. This book is called Rethinking Contract Law and Contract Design. It's been written by Victor P. Goldberg, and as I say, from Edward Elgar, and it's in the Rethinking Law series. I'll show you the book in just a minute. Elizabeth and I thought about this book because the issues of contract law are really quite important at the moment. We're going through another big change in the way in which contracts are viewed and reviewed, if you like, by the legal community and the wider world. But we gave the review of this book the title, A Current and Radical Rethink on Contract Law, an Important Contribution to the Debate. And I'm sure this debate is going to continue, because one of the things that's always struck me teaching the subject, as well as acting in court for parties, breach of contract matters and so on, is the difficulty by which people understand how a contract is created and what the implications are. The difficulty being that you think a contract is a very simple, straightforward matter, but it isn't. Classic example being the invitation to treat, and the fact that when you actually go up, when you go into a shop, a self-service shop, and you have goods which you want to purchase, the first question, and the one the students always have the difficulty with, is when I produce the goods that I want to purchase and I give them to the cashier, who makes the offer and who makes the acceptance? And we start on that basis. A lot of preconceived notions about contract change. Then of course you've got the interference of statute law in what you can and can't sell and who you can sell to and so forth. More about that in a minute. Let's have a look at the book first. It's the book, lovely cover, very modern cover, black and white, spine and then the back. Lots of doors on the front. As you can see, the book itself is a hardback. It runs to something approaching just under 300 pages. There's a nice index at the back. Very much the style for Edward Elgar, I hasten to add. Very detailed bibliography, to be expected. These are high style books. There's a nice little point right at the end, which I did find interesting, his concluding remarks. Because I think this is, again, it's only a very short bit. The unifying concept of this book is that an economic understanding of contract design will illuminate both contract doctrine and contract interpretation. Then he talks about remedies. The point is, it sounds a little bit complex, but when you sort of move it about a bit, you'll find that what he's saying is relatively straightforward to understand, I think. And having said that, there are a lot of complicated books about the modern law of contract, which are not the easiest to read. There's the Rethinking front page, and this is the actual series itself. Do have a read of that to get an idea of what... this is the first of a number of books that are coming in. There's one on cyber law as well, which is available. This is the contents section. This is available, of course, as an e-book, and it's online as well. And there information there. Do have a look at that, because that's where you find the information about e-book and online details. So as I say, that's the contents section itself. And some acknowledgements there. And then you've got a table of cases. Nice little cases there. They are actually United States cases, international cases. But Carlyle isn't there, you'd be interested to know. But however, introduction, because this is the wider picture, wider concepts. Then you get into the body copy of the book itself. There is a little bit of numbering. There's no paragraph numbering. There's no footnotes, for instance. You've got, as I say, got a little bit of the subheading numbering there. But you do have quotes and various other things in. But all the detail is right at the back. And for instance, right at the end, part 4, offer and acceptance. But again, you've got the same discussion. I mentioned that earlier because that's quite an important area. And of course, you've got a number of cases, but they are basically American. But remember, it's all common law. And although they're American, they are persuasive of what we will do here. And one of the things I would like to see certainly would be a call to review what we do about the law of contract, because We have, for instance, the classic problem with selling and buying a property, where the laws of contract don't seem to apply at all because of the delays and the concept of gazumping and so forth, gazundering. The whole thing does seem to have made the basic principles very complex, and it would be nice to try to simplify a bit of it. Now, let me talk about what the book's about. This is what we've said. Victor P. Goldberg, who writes this book, is the Jerome L. Green Professor of Transactional Law at Columbia University. His observations on contract law, which he generally approaches from an economic perspective, are meticulously argued and, more often than not, radical. Very interesting too, because I think there's going to be a continuing debate on this within the common law world from the jurisprudence involved. So I think it's quite important to bear in mind where he is coming from at his particularly high level in terms of the overall scheme of things when it comes to contracts. How appropriate then that this volume has been included as one of the latest titles, one of the earliest ones if you like, of Edward Elgar's Rethinking Law series. Contract doctrines, which most regard as efficient, are, in Goldberg's view, terribly inefficient in many instances. Just how and why he reaches this conclusion is explained in detail in this thoughtful and analytical work, which it incorporates in about a dozen, if you check the index, of the author's previous essays and articles. So it's really partly stuff he's already discussed, but he's brought everything together into the one area, and I think it's very helpful. Many of these points, of course, that he's raised in the previous essays and articles have been revised and represented as new material, as a follow-up, if you like, and I think that's also helpful. Indicated by the title, of course, the book focuses on how parties to a contract design their contractual relations. With such an approach, says Goldberg, the reader can glean insights into doctrinal reform and contract interpretations. Absolutely. Conceivably, such a stance is useful in the more complex contractual disputes, which don't include those involving everyday consumer contracts or agreements between amateurs. Quote, "For my purposes," says Goldberg, "the category is defined by agreements for which both parties could be expected to have access to counsel." The subject matter of the essays contained in the book is diverse and illuminating, as numerous US cases are analysed with a view to reassessing key doctrines in contract law with a view to possible reforms. And that's where the persuasive influence, I think, comes into the English legal system. Yes, the context of the book is American, but its focus throughout is on contract design based on a common law model, I would submit, as well as, in the words of the author, the economic problems confronting contractual parties and the tools for coping with them. The book's divided into 4 sections to include the following: direct damages, consequential damages, excuse and changed circumstances, that includes the excuse doctrine, finally often acceptance, with reference to specific cases throughout, all mainly being Americans and international, not much from the English side. What seems to emerge throughout these discussions, as you would expect, are inconsistencies, controversies and debate. The point I've made, which I think is important, is it, like many areas of law, is becoming very, very complex, and we would like to see a bit more simplicity, I think, with some of the rules, but we'll see where we go. For instance, let me take some examples from the book which highlight the inconsistencies and controversies Goldberg's identified. The first 2 sections of the book focus on remedies. Remember, remedies, big thing students always miss quite often in problem questions in exams. You always want to look at the remedy because that's what the client is coming to you for assistance on, if you're a barrister, for instance. The example is cited of 2 cases in which a book publisher accepted an author's manuscript, then refused to publish it. In one case, the unfortunate author received a nominal 6 cents. In the other, the author won restitution for his or her time of over $300,000. Sounds like the second author had a better lawyer, but you see again the inconsistencies sometimes, possibly with the common law, and the fact that the contract law does go up and down, it's weave a bit And that's one of the problems. I think we could do with a bit more stability in the concepts, personally. Now, the book offers certainly valuable insights and new perspectives on the often thorny problems of contract law, as it can and does affect sophisticated parties. Lawyers as well as academics on both sides of the Atlantic, we think, will welcome the important contribution made here to the ongoing debates which rage continually within this core area of law. And the publication, as I say, of this book is cited as at 2015. It's a delightful book. I've always been interested in contract law from 45 years ago, when I first picked up my Chitty on Contracts, and just thought it was an absolutely fine read. And that's from the Common Law Library, Sweden Maxwell, here in UK. This is the book anyway. There's the front, the side, and then the back again. Just have a look at the Rethinking Law series. Part 2, Consequential Damages. You see it's split. It's nicely laid out, this book. And he talks about teaching contract law there, which I've taught as well. When I first taught contract law, came to the subject of consequential damage, I took a look at the UCC, and I was taken aback at the UCC comment. Obviously these are particularly important points, going back a long way to Holmes, in fact, which you can see there is the tacit assumption rule. But you see again, even from some of our textbook writers, I'm thinking of some of the main contract law textbooks we have, the fact that before you get anywhere, you suddenly find that contract law becomes much more complex than you would actually have thought it to be. As I say, the Bible for this is Chitty on Contracts, because that actually sets out, in very simple English, I think, exactly where we are, because some of it is so complicated. And I don't see that it's going to get any simpler, personally, but it's useful to have this as the debate continues and rages. Thank you, Professor Goldberg and Edward Elgar, again maintaining a really high standard for which we are very grateful in both the practitioner and the academic worlds. Bye-bye.